Hey guys, middle week of June here. We're going to do our legal tip on be careful with wholesalers. I'm going to warn you about something that I see happening in the marketplace. You really need to listen to this whole legal tip here because I'm seeing this happen all the time. Talking about wholesaling. What is wholesaling? So when somebody buys a piece of property, immediately starts trying to sell the contract to somebody. They're not intending to ever buy it. They're simply trying to sell the contract. An example would be, I'm going to buy a house for $100,000. I sign contract. As soon as I get the contract, I start shopping the contract for $120,000. So that what ultimately happens is you buy the property from the seller, and then I get to pocket $20,000 profit, never owning or touching the property. That's called wholesaling. There's a lot of illegal acts in doing that, and the fact that how they're done. Now, that's a whole different subject. We can go on I've done a podcast, matter of fact. So if you'll go check on blaircato.com, it's on our website. You also hit the podcast button and scroll down to the very first podcast I did with Candace McEwen on it. And you can hear all about wholesaling and how they're done illegally or improperly. But this is a little bit different. What I'm talking about here is you have an investor who signed a contract to buy a house, and now he wants you to list the house, basically listing his contract so he can sell his contract to somebody else and make his flip money. That, I believe, is not going to be proper under our law. And if you look at 40-57, 135E, and we'll read it to you. It says a licensee may not advertise, market, or offer to conduct a real estate transaction involving real estate owned in whole or by part by another person without first obtaining a written listing agreement. You already know that. Between the property owner and the real estate brokerage in which you are licensed. It says property owner. It doesn't say contractual interest, equitable interests, or legal interest. It says the property owner. And the wholesaler is not a property owner. They have a contractual right to buy the property. That is it. So you may not market, advertise, or list property unless you have a signed listing agreement by the owner. So if a wholesaler wants you to list his contract or his right to buy the property so that he can flip it to somebody else, the only way you can do that legally is to go out and get the listing agreement signed by the owner of the property. There's too many of them I'm seeing in MLS that don't have listing agreements signed by the property owner. It's very evident by the way they write up in here that the property is an investor and he doesn't own title. He has a right to buy it. Unless you have a signed listing agreement by that property owner, you're in violation of 135, 40-57, 135. And that's my opinion. All right. So be very, very careful with it. You're starting to get approached by a lot of these wholesalers, and I don't want to see you guys get in trouble. All right. Y'all have a good weekend. Talk to you real soon.